Minister, this week your department confirmed to Gript Media that October last year a new process was adopted whereby presenting officers are not automatically appointed to defend the public's case in international protection appeals tribunal hearings against decisions to refuse asylum applications. Your department said this was done to speed up the process of appeals, but in effect it means that someone is appealing a decision to refuse them asylum here is in many cases not being opposed by the state, and that your department is informally defending its own decisions in that regard. How can the public have confidence in the appeals tribunal's decisions when in many cases the tribunal isn't even hearing the case against letting someone stay here?
So that's not correct to say that we're not defending cases. I think
in some cases, increasingly, the department has confirmed that to Gript last week.
So I think on average just under 70% of cases through IPAT are rejected or the appeal is upheld. That hasn't changed this year, last year or the year before. What was decided was that there wasn't a need for a presiding officer at some of the more simpler cases, so in particular for the safe countries, of which we had a significant number applied last year. We felt it wasn't needed because of the fact that these cases were much simpler. Obviously this is kept under review, but you can see clearly from the figures last year compared to the year before, it's still about 70% of cases that are actually upheld. It's just to make sure that we are using our resources as efficiently as possible. Where we don't need those resources, we need to be able to use them in other ways, be it in the IPO or other offices where there's obviously a huge amount of work being done.
Is it not